Hello, welcome to our program on immigration and you. I am your immigration attorney Michael Phulwani, and once again we have with us attorney David Nachman, my partner. David, welcome.
Thanks so much, Michael. Always a pleasure to be here with you.
Thank you. Now, before we start our today's program, which we are going to do with the cutoff dates for the month of October 2013, there's a little announcement about David's trip to India. And David, can you please give information to our viewers?
Sure. Thank you, Michael. Actually, I just want to let all of our loyal viewers know that I'm going to be traveling to India in the month of November. Actually, in early November, I'm going to be traveling to New Delhi. And from New Delhi, I'll be also going to Chennai, to Mumbai, and actually we're going to be doing a side trip to Goa this time. And for anyone who is interested in meeting me while I'm in India, please feel free to send an email or to call our office. We'll be more than happy to try to organize a meeting. If you have any family members who would like to, back at home, who would like to meet with me to speak about potential options for U.S. immigration, we're happy to do that. Michael will not be joining me on this trip, but we're actually talking about the possibility of doing another trip early next year.
Correct.
So, again, this is a great way for you to present me with some of your information, some information about your family, and then, of course, Michael and I can discuss ways in which we might be able to assist you and your family with your immigration matters. So I'll be.
In case you want to reach David while he's in India, you can always contact me also, and I'll call David and set up an appointment for any friend relative with David in India.
Exactly. Of course, in Mumbai, I'm going to be spending quite a bit of time in the Mumbai office, and so you can feel free to reach out for Michael directly, and you can email him, you can email me. I'll be checking my emails, of course, and we'll be able to organize a meeting for you. Interestingly, I will be attending, I'll be actually traveling with a delegation of 25 other lawyers from the United States, and we'll be going to these various cities and taking in the sites and meeting with consular officials. So really the thrust of the trip will be to get as much information as we possibly can for you, our viewers, about administrative processing, about the new DS 260 processing, the U.S. consulates, and all of the other great information that we provide to you about U.S. consular processing abroad. So I hope to be able to bring that back for you.
Okay, let's start the program with cutoff dates for the month of October 2013. The family preference categories: the family first preference, which is for the unmarried sons and daughters over the age of 21 of U.S. citizens, advances by 2 weeks for all the countries including India to October 1, 2006. The family 2A category, which is for the spouses and unmarried children under the age of 21 of green card holders, cutoff date is established now. By the way, because in August and September, this category all of a sudden became current. We'll talk a little more about our advice that we gave to the viewers last time, and even now we can talk a little more about that. But now in the month of October, they have established a cutoff date, which is excellent, not much really. The cutoff date is September 8, 2013. As good as current, but not current. And we can talk a little bit about
not
those
too
people.
Bad. Yeah. Not too bad.
Yeah. The family 2B category, which are the unmarried sons and daughters over the age of 21 of green card holders, advances by 2 weeks to March 1, 2006. The family third preference, which are the married sons and daughters of U.S. citizens, unfortunately did not move. Date remains the same, January 22nd, 2003. And the family fourth preference, the brothers and sisters of U.S. citizens, advances for all the countries by 2 weeks to August 8, 2001. Now, in the employment preference categories, the first preference, which are the priority workers, is current for all the countries including India. The employment second preference, the advanced degree holders, is current for most other countries except India. Unfortunately, there is no movement for India in this category, and the date remains at June 15, 2008. of course, it did not move, but remember, in the last 2 or 3 months, it advances by 3 to 4 years at least. So that was a very good news, and we can talk a little bit more about David and me in the comments on the family 2A and the EB2 category. So let's continue. The employment third preference, there is no movement for both other countries and India. Other countries other than India, the date remains the same, July 1, 2010. And for India, it remains at September 22nd, 2003. And the other worker category is the same like employment third preference that we just talked about. The fourth preference, special immigrants, which include religious workers, priests, and all that, is current for all the countries. And the fifth preference, investors of $1 million and $500,000, is also current for all the countries. Now, two of the categories that I mentioned, let's talk a little bit about family second preference, and I'll make a comment and David is going to talk a little more about that. In August and September, when it became current, we advise people that if you are a green card holder and your spouse is in the US on a valid visa, it's a good idea at this point to file an I-130 and a 485 right away in those months, and then you will be able to get a permission to stay and maybe in most cases permission to work also. And so a lot of people, few people we did help at that time, and we already knew, it's nothing a shock or a surprise, that we knew that once the new year starts, and we knew also that David and me are in touch with the officer in the Department of State who every month tells us about the cutoff dates. So right now the strategy on F2A is that same thing, if you have a spouse here, file only I-130 now, that establishes a priority date. Then maybe in 2, 3 months, 4 months, whatever time it takes, if that number becomes available, then the person can file 485. Bottom line is still we can accomplish the same objective, except the green card issuance may be delayed for some period of time. Now let's talk about EB2 category, David. Remember, as I said, it was so much backlog, people were crying, waiting in the category for years, and it jumped from more than 4 years actually in the 2 months. Now, what happens now going forward? Predictions, number one.
Well, now, of course, it's the beginning of the fiscal year. The government fiscal year runs from October 1st through September 30th. So we're likely to see, so basically there's no movement. That's unfortunately, and what that means is that, and we're receiving a lot of calls in our office from individuals who may in fact qualify for EB1. So they have EB2 cases, but their credentials are maybe a little better. So they've locked in their EB2 priority dates.
Even David,
now they're
looking
at
point.
EB1.
Even those clients that are calling, those who already have this priority date, available visa number available now, they can still file a 485. Or those cases, remember, in December 2007, visa numbers in employment categories became current, and many of our clients filed their I-130s, I-140s and 485, and got the EAD and sitting there for visa number to become available.
And they're just waiting for the...
And because this is 2008, all those people had before 2007. So all those people can contact their lawyers or somehow pursue, because their visa number is available. They should be able to complete and give them
If the priority date is current, they can obviously file the adjustment. Sure.
And you are talking about also now...
Well, now I'm talking about individuals who have EB2 cases locked in.
Yeah.
They have a priority date set, and their resumes obviously over the years have gotten a little better. So what they may want to do is they may want to take a shot and file the EB1 classification and see if they get it, because it's current, so it's not backlogged. So we are receiving a lot of calls with inquiries of that nature. Yeah.
Some other question came, which is not directly related to the cutoff dates. It's coming to my mind about the H-1Bs that have a limit of 6 years.
Right.
And the 6 years are going to be up in the next 2 or 3 months. And this person never applied for a labor certification. They are a big problem, because it's very difficult to get an extension beyond 6 years unless he had filed some kind of application, labor cert, petition, at least a year before. Let's talk a little more about that. Explain to our
Well,
viewers.
Michael, I think what we're talking about here is AC 21. It was actually a provision that came down just about the time of AC 21. It was actually not incorporated within AC 21, but what it did is it provided that if you filed your labor certification application, your PERM, prior to the end of your 5th year, then as long as the PERM application is pending for 365 days, you can extend your H-1B in 1-year increments. Of course, once the I-140 is approved and filed, then you can extend in 3-year increments. And the problem that you're bringing up, which I think is a really good one, and one that we keep continuously see on a daily basis, we get calls about this, is what happens if the individual waited too long? Right. What happens if they waited beyond the end of the 5th year? So they're now into their 6th year. Well, there's such a thing called recapture. And so what we would oftentimes do is sit with the employer and the employee, maybe the employee only, and try to explain to them how to recapture the time, to reconstruct the end of the 5th year. So if they make the filing before the end of that 5th year, then of course they would hopefully be able to take advantage of those 1-year increments. We call those 7th year H-1Bs.
Well, I had a situation which is we call a creative lawyering. This person had not filed a labor certification in a timely manner to be eligible for the 7th or 8th year. He was already at the end of the 5th year or the beginning of the 6th year.
Okay.
But there's going to be a gap, like once the 6-year period is up, you're not going to get an extension, and then it's a bigger problem.
Right.
So I said, okay, why don't you just take a 3-month vacation, go home, enjoy, have a little fun, and you come back. Exactly. And then what we'll do, end of that close to 6 years, we can file an recapturing. So you get another extra 3-4 months, which takes away that parallel labor certification to 1-year period. And then we go on the 7th and 8th year.
Exactly. Well, I think it's a great idea, and it's reconstructing the end of the 5th year. So that's exactly what you would want to try to do if you can.
Right.
Exactly. And I think that our viewers need to also need to keep in mind the possibility also if an individual goes outside the United States for 1 full year, and I believe that that's part of this creative lawyering that you spoke of, is that if you go outside for 1 full year, then you can come back in on a new H-1B and get a full 6 years. So there's some advantage to doing that. And also, don't forget that another thing that we can do is change an individual's status in the United States. So if there's a possibility that the individual is running out of time, we can possibly, if let's say your spouse is H-1B and you're H-1B, you can bump to an H-4. Correct. But of course, keep in mind that you won't be able to work. Bump to an H-4, and then you can always switch back to the H-1B later. If
you want to study something further, you may be able
F1,
to change
switch to an
from
F1.
H-1B student visa. You cannot work,
but you have to be a little careful with the dual intent issue there.
Legally stay here in the U.S.
Exactly, but you have to be careful with the studying, because you don't want to bump someone to F1 if they're pursuing the green card, because of the dual intent nature of the H-1B versus the F1, which doesn't have dual intent.
That is correct. Right. No, listen, we're talking about filing a labor certification. The question is, what is the best time? Because, we are advertising and the process has to start earlier. So would you say question, 3rd year or the 4th year or the 5th year?
It's a great question. We get that from clients all the time, and they're always asking us, what's the best time to file the PERM labor certification? And we always say, as quickly as you possibly can.
Correct.
So, of course, we're talking about people who delay and delay and delay and wait till the end of the 5th year, but don't do that. That's the very last period of time that you can do it. File it as soon as possible. So as soon as you take up your H-1B, which could be for some of you October 1st, then you can start your green card process. That's not a problem at all.
Thank you very much, David. We're running out of the time, and we have a lot of interesting things, important information that we will continue in our forthcoming programs. And thank all of you. Namaskar, Adab, Sat Sri Akal. फिर मिलेंगे next Saturday और Sunday को यहीं पर ITV विजन आवेशा पर. Thank you.